This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why Progressive obtained a judgment of no coverage by default because the vehicle was not identified in the policy that was the subject of a claim seeking defense and indemnity. In Progressive Specialty versus Willie Richardson, the United States District Court for the Northern District of Alabama on February 5, 2025, Plaintiff Progressive Specialty moved the United States District Court for a default judgment. Progressive sought entry of default declaratory judgment against the defendant, Willie Richardson. The key points of the case were that 1. The vehicle involved in the accident was a 2015 Nissan Pathfinder, which was not listed as a covered auto under the Alabama auto policy issued to the defendant. 2. Progressive argued that the vehicle did not qualify as a covered auto because it was not shown on the declarations page, was not an additional or replacement auto, and was not a trailer owned by the insured. And 3, the defendant failed to respond to the complaint that was properly served on the defendant, leading to default. Progressive Specialty filed a complaint on July 19, 2024, seeking a declaratory judgment that it does not have any insurance coverage duties to defend or indemnify Willie Richardson in a lawsuit pending against him in the Supreme Court of the State of New York, County of Queens. The lawsuit involves a pedestrian, Estefania Aragones, who was allegedly struck by a vehicle owned by the defendant on May 12, 2021. The vehicle which allegedly struck Aragones was a 2015 Nissan Pathfinder. Progressive alleged that the title documentation reflected that Willie Richardson was the owner of that vehicle, had purchased it on July 4 of 2018, and obtained title to it on July 17 of 2018. Progressive alleged the vehicle involved in the alleged May 12, 2021 accident would not qualify as a covered auto because it was not shown on the declarations page for the coverages under the policy. Progressive further alleged the vehicle would not qualify as an additional auto because the defendant had owned it for nearly 3 years but had never sought coverage from Progressive. When defendant has failed to plead or defend, a district court may enter judgment by default, this being Federal Rule of Civil Procedure 55B2. The Federal Declaratory Judgment Act limits relief to actual cases or controversies. That is, under the facts alleged, there must be a substantial continuing controversy between parties having adverse legal interest. In order to demonstrate there is a case or controversy that satisfied Article 3's standing requirement when a plaintiff is seeking declaratory relief as opposed to seeking damages for a past harm, the plaintiff must allege facts from which it appears that there is a substantial likelihood that he will suffer injury in the future. These allegations, which are now admitted based on defendant's default, are sufficient to establish that Progressive does not have liability insurance coverage duties either to defend or indemnify the defendant under the Alabama auto policy issued to him by Progressive. The court concluded that Progressive does not owe any liability insurance coverage duties to the defendant to defend or indemnify him in the underlying case. The clerk of the court entered default on December 17 of 2024, and on that same date, a notice of ability to request pro bono counsel was issued to defendant. This notice provided the defendant had 30 days from the date of the notice to request appointment of pro bono counsel to defend him. Despite this notice, defendant has not filed a request for appointment of pro bono counsel or otherwise responded to the action. For the reasons explained above, Progressive's motion for default judgment was granted. In my opinion, as I have said often, insurance is a contract, just like any other contract. The Progressive policy contract provided coverage only for accidents that occur while operating a vehicle identified in the policy as an insured vehicle. The Nissan Pathfinder was not identified on the policy, and therefore judgment was entered in favor of Progressive, who owed nothing to the defendant. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and access to the more than 4,950 blog postings. You can also subscribe to the videos at rumble.com and at youtube.com, and if you do, I'd appreciate it if you click on the thumbs up button at Rumble and the like button on YouTube. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. You can also subscribe to the free portion of the Substack publication and will receive notice about all of the blog postings. Thank you for your attention.